The 6 principal mobiles on this red network all made their last calls in the minutes before the attack on Mr. Hariri. They were never used again after that. This group of mobiles was completely anonymous. There were no calls outside the group and no texts were sent within it. The only evidence the investigators had of their use was the cell towers to which they were connecting and when, and which numbers they were calling. From this, they tried to find out who was using them and who were the callers. The investigators then examined other mobiles that were in the same cell sectors at or around the same time. Did what is called a, quote, cell dump, unquote. Now that involves examining the records of all connections to specified cells and filtering for which mobiles are contacting each other or contacting others. They look for patterns and then repeat this with target mobiles in other cells that the mobiles connect to. They were trying to find whether mobiles were doing what's called co-locating. Now, co-locating simply means that the mobiles are travelling together in such a manner that one person could be using more than one mobile. To illustrate, a common example is of someone carrying both their work and personal mobile around with them in their pocket or their bag. When 2 mobiles are together, they will connect to the same cell towers. The mobile can be identified through the unique number of each handset and the SIM card that every mobile has. Now, normally, we might expect that a work mobile will be predominantly used during working hours, and a personal mobile more frequently used out of work hours and in different areas. But whichever it is, most people leave a distinct geographic signature when using their mobiles. Most people habitually use their mobiles in the same areas and, for example, don't use them at night when they're at home asleep. They may receive SMS messages when they are not using the mobile because they are sleeping, but the cell where the mobile is when it receives the text is recorded in the call data records. Thus, we can normally know where a mobile was during the night unless it was switched off. The first use of a mobile in the morning and the last use at night leaves clues as to where the user is staying that night. Most people also have a pattern of contacts in who they call, text, and message. This too can provide clues as to who is using it. If investigators have the mobile in their hands, they can of course examine it for other clues, such as notes, photographs, encrypted messages, and so on. But the investigators here only had the cell tower connections to go on. Every cell tower has an area of what is called its predicted best server coverage area, which is normally divided into 3 triangular cells on each tower or mast. That simply means the place it is predicted that your mobile will connect to cell A as opposed to cell B or cell C. Each cell has its own name, but this isn't an exact science, as the predicted best coverage areas overlap, especially around the edges, meaning that your mobile can potentially connect to more than one cell. Or if the network is congested, the call may be directed to the next available cell, which will be one of the cells surrounding the one that the mobile actually physically is in. To work out if mobiles are co-locating requires some cell site expertise. Someone who understands cell coverage areas, the principles of radio propagation, radio wave propagation, and how mobile networks operate. These experts will examine the call patterns of the target mobiles to work out if it is possible, and it is stressed here possible, that 2 mobiles could have a single user. Sometimes no particular expertise is needed to work this out. For example, if 2 mobiles always connect to the same cells at the same time every day, or if 2 mobiles make separate calls in different cells, but where it's possible to travel the distance between the cells in the time between the calls. For example, 2 cells 2 kilometres apart with calls made in each cell within 15 minutes of each other. But this can be far from straightforward, as mobiles connect to cell towers by radio propagation. The radio waves from the cell and the mobile will hit and bounce off buildings and hills and other geographical features, and can take shortcuts across water far from a predicted coverage area. This can make it difficult to pinpoint where the mobile is. The networks use their own predictive software to show the predictive best server coverage of each cell on a tower. This is for commercial reasons, to provide the best coverage possible for their customers. They can change the coverage area by adjusting the cell tower antenna, by changing its angle up or down, for instance, or installing a relay station, or in extreme circumstances, a new cell tower. The predicted coverage areas also don't come in neat semicircular triangles. Rather, because of topography, including tall buildings, these can be very patchy, meaning that bits of the predicted coverage of cell A can be in the middle of the predicted coverage area, one using it on the western side or the ground floor. The cell you connect to while walking in the street might not be the one that your mobile connects to while you are using it in the back garden of a house in the same street. So some expertise is required to interpret the call connections. And as a further complication, the trial chamber received evidence that Lebanon's Alpha telecommunication networks predicted best serverage coverage maps of 2004 and 2005. Covering the indictment period were only around 60 to 70% accurate. Now that's good enough for the network's commercial purposes, but it's not good enough to pinpoint precisely where a mobile is. So a mobile's connection to a cell can only approximate where a mobile is, and this is only to the extent that it will be most probably connecting to the cell that provides the predicted best coverage area to where the mobile actually is. In this case, that was the only evidence that the prosecution had of where the mobiles were. That is, the personal and network mobiles that the prosecution said that the four accused and Mr. Badruddin were using. There was no GPS to isolate their location, and no direct evidence of who was using a mobile and when and where. There were no smartphones in Lebanon in 2004 and 2005. The case was entirely circumstantial. The only exceptions were when witnesses testified as to where they were at a particular time, and the cell site data of their mobile connections matched this. This was particularly important in pinpointing Mr. Hariri's locations when he was under surveillance. His bodyguards used their mobiles, and the media covered his appearances. His office kept records of where he went and when, and of his numerous trips out of Lebanon. Putting these things together, it is possible to conclusively establish where he was and whether any network mobiles were nearby at the same time. If they were, the trial chamber could then consider whether the network mobiles were conducting surveillance of him, or, alternatively, if their presence there was simply coincidental when compared to where they were before and afterwards. For example, if Mr. Hariri visited a church and the network mobiles started connecting to cells covering the church, or he went out to lunch and the same thing happened, or he travelled to his Fakra village about 50 kilometres north of Beirut in the Suriah area. And the network mobiles were suddenly connecting to cells along the route on his way there and back. Patterns emerge. And it is the consistency of these patterns that allows conclusions that these things are beyond coincidence. The trial chamber heard evidence of all of these facts. What has just been said is a way of explaining it in a simplified manner for the purposes of this pronouncement. It's explained in much greater detail in the summary and in the judgment. The trial chamber heard a lot of evidence about whether the prosecution's cell site evidence was reliable. The trial chamber has concluded that it was sufficiently reliable to use to establish where mobiles generally were. This is reliable enough to establish the patterns of travel of multiple mobiles. For example, if they travel in the same direction in a manner in which collocation is possible, and the sample size is sufficiently large to draw this conclusion, meaning the more calls, the longer the period, and the more they travel. But it is nowhere near 100% reliable. But this is not necessary to establish these patterns. It becomes more important when precision is needed to place someone at a certain place, like a particular payphone or a mosque or a tree at a specified critical time. If someone is alleged to have used a certain payphone at a particular time, and the only evidence of this is that their mobile connected to a nearby cell at around that time, this is far more difficult to prove. The prosecution and defence used what are called call sequence tables to show the call connections, cells, mobiles, and texts. These are extracts from the call data records of the telecommunications companies put into tables. Without these, the call data records are just strings of incomprehensible numbers. Turning to a fundamentally important matter, the standard of proof. The prosecution must prove the guilt of the accused beyond reasonable doubt. The accused are presumed innocent until a verdict of guilt is entered against them. The trial chamber considered every crime and charge against each accused individually, determining for each whether the evidence establishes beyond reasonable doubt all facts indispensable to a conviction. The trial chamber judges voted separately on each charge in the indictment, and also, if necessary, to make separate findings on whether each accused was guilty as charged. The verdict here is unanimous on each count. The trial chamber has assessed each piece of evidence in the context of all related evidence. Taking this approach is particularly important in evaluating the prosecution's telecommunications evidence. The evidence against the four accused, as said earlier, is almost entirely circumstantial. It is only from reviewing the relevant facts in their entirety that a chamber can see patterns that could potentially emerge, from which conclusions could be drawn that they are so striking as to be beyond coincidence, and hence provide proof beyond reasonable doubt of facts that are indispensable to a conviction. The trial chamber is also acutely aware of the difficulties in attempting to assess the reliability and credibility of witness testimony, especially in an international setting, through interpretation, and many years after the attack on Mr. Hariri, in evaluating the evidence of each witness. Turning to the political background and context to the attack. The trial chamber received extensive evidence from the prosecution and also the defence of Mr. Hussein Hassan Anesi concerning the political and historical background to the attack on Mr. Hariri. Mr. Marwan Hamadeh, Mr. Walid Jumblat, Mr. Fouad Signora and Mr. Jamal Sayed and other politicians and Lebanese officials testified about the events leading to Mr. Hariri's assassination. The trial chamber, it is stressed, has no role as a trial court in either writing or correcting any version of history that witnesses or anyone may have urged upon it. Its role is to decide only whether the four accused are guilty beyond reasonable doubt of any of the charges on the indictment. The attack on Mr. Hariri, however, did not occur in a political or historical vacuum. The trial chamber cannot ignore the background to the attack as providing a possible motive for it. Motive, though, is not a legal element of any of the crimes charged. The assassination by car bombing of a prominent politician who had recently resigned as the Prime Minister and was preparing to contest the next parliamentary elections was undoubtedly a political act. Understanding the political background to the attack gives context to why Mr. Hariri was targeted in this manner, but only as it relates to whether the accused on trial are guilty of any counts charged on the indictment. The evidence showed Syria's overwhelming political, military and economic dominance in Lebanon after the end of the tragic civil war. Opponents of the Syrian presence included Mr. Jumblat's Druze political faction, Christians and members of Mr. Hariri's own future movement. Mr. Hariri's political allies vocally supported a United Nations Security Council resolution, number 1559, which, in September 2004, called for the disarming of militias in Lebanon and the withdrawal of foreign troops from Lebanon. One militia was Hezbollah's. The soldiers were Syrian. The Syrians even imposed electoral candidates on Mr. Hariri. These were known as the, quote, Syrian deposits, unquote. Mr. Hariri resisted. He did not want this. The Syrian government, over Mr. Hariri's opposition, also wanted to extend President Emil Lahoud's term-limited mandate. This could only be done by the Lebanese parliament changing the constitution. In August 2004, the Syrian president, Mr. Bashar al-Assad, effectively ordered Mr. Hariri to support Mr. Lahoud's mandate extension, stating that Syria alone would choose the president of Lebanon. In the months before his assassination, Mr. Hariri's allies were publicly calling for an end to the Syrian political, military and economic dominance over Lebanon. His supporters held 3 meetings in the Bristol Hotel in Beirut and issued calls for the end of Syrian domination of Lebanon. These occurred in September and December 2004, and a final one just 12 days before his murder. That occurred on the 2nd of February 2005. These meetings came to be known as the Bristol Group meetings. There was also an attack on the life of Mr. Hariri's political ally and friend, Mr. Marwan Hamadeh, on the 1st of October 2004, when a car bomb exploded outside his house. Mr. Hamadeh escaped death and was seriously injured in the attack, but his bodyguard died and another person was seriously injured. Witnesses testified that the attack on Mr. Hamadeh could be construed as a warning to Mr. Hariri and Mr. Jumblat not to cross the line in relation to the Syrian regime. Mr. Hariri resigned as Prime Minister on the 20th of October 2004 and was planning to run in the May 2005 elections. He would have been proposing the loosening of Syrian dominance over Lebanon and the immediate withdrawal of Syrian troops from Lebanon. The Syrian government, however, was supporting a new electoral law designed to diminish Mr. Hariri's chances of having members of his bloc elected to parliament, and hence his prospects of a new term as Prime Minister. The Syrian government was also insisting, over Mr. Hariri's opposition, that he accept the so-called Syrian deposits in his electoral list. Mr. Hariri also regularly met senior Syrian officials operating inside Lebanon. These included the chief of Syrian military intelligence in Lebanon, Mr. Rustam Ghazali. Over more than 11 years before his death, from 1993 to 2005, Mr. Hariri paid millions of US dollars and in regular month cashly payments to Mr. Ghazali. This included, significantly, a double payment on Sunday the 13th of February 2005, the day before the attack on Mr. Hariri's life. The payments were seen as a form of blackmail necessary to preserve the relationship. The trial chamber is also satisfied that Mr. Ghazali had a good reason to demand this timely, final double payment from Mr. Hariri. The growing opposition to the Syrian presence in Lebanon threatened Syria's interests. The trial chamber is of the view that Syria and Hezbollah may have had motives to eliminate Mr. Hariri and some of his political allies. However, there was no evidence that the Hezbollah leadership had any involvement in Mr. Hariri's murder, and there is no direct evidence of Syrian involvement in it. The trial chamber also received evidence that Hezbollah's Secretary General, Mr. Hassan Nasrallah, and Mr. Hariri had good relations in the months before the attack, and that Mr. Hariri supported the disarming of Hezbollah's militia only once peace with Israel was achieved. For the reasons set out a little later in this pronouncement, the trial chamber has found that the date when the conspirators decided to proceed with the attack on Mr. Hariri's life coincided with two important events in early February 2005. These were, first, a visit to his home by the Syrian Deputy Foreign Minister, Mr. Walid El-Mualim, on the 1st of February 2005, and second, the next day, a third meeting of the anti-Syrian opposition at the Bristol Hotel in Lebanon. I turn to Judge Nosworthy, who will read the next portion of the judgment.
The trial chamber now deals with the victims. The explosion had a terrible, devastating and dramatic impact and effect on its victims. Participating victims provided direct evidence of the terrible consequences of the attack. Families lost spouses, parents, siblings, carers, children, and other close relatives. Some suffered catastrophic injuries. 15 and a half years later, the scars remain. Some still suffer from post-traumatic stress disorder. Many have permanent injuries. There is no doubt that terrorism is one of the most serious and heinous crimes, and that the attack was very grave. The gravity of the crime encompasses its impact on the victims. The harm suffered by the victims, the lost lives, personal injuries, or the loss of a family member cannot be restituted as restoration of the original situation of the victim before the violation is impossible. The judgment highlights what happened to many victims. The trial chamber cannot order reparations, but it may identify victims, which may assist them in claiming compensation before a national court or other competent body. The trial chamber is satisfied beyond a reasonable doubt that direct and indirect victims suffered harm. The disparity in treatment among the participating victims as to, quote, compensation, unquote, meaning financial, for the loss or damage suffered was dramatic. Some victims received money from a state body, others from the Hariri family. Most received nothing. Victims who provided evidence felt a real sense of injustice because some were compensated while most were not. Compensation for victims of serious crimes must be appropriate and proportional to the gravity of the harm suffered. It should not depend on the circumstances of the victims, their connections, employment relationship, or insurance scheme. As a general proposition, the trial chamber agrees that victims of crimes should be entitled to receive a form of statutory compensation. The trial chamber, at the invitation of the legal representative of victims, reminds the Lebanese government of the UN Declaration of Basic Principles of Justice for Victims of Crimes and Abuse of Power, of the need for just compensation, quote unquote, for the victims of crime. It also reminds the Lebanese government of the importance of having an adequate compensation scheme for victims. As an alternative, a voluntary trust fund could be established to compensate the victims in the cases within the tribunal's jurisdiction. We now turn to the attack. Turning to the attack in more detail. On the morning of Monday, the 14th of February, 2005, Mr. Hariri left Kuratum Palace to attend a morning session of the Lebanese Parliament. Shortly after 12 noon, he left Parliament and went to the Café Place de l'Étoile, opposite where he stayed for around 45 minutes. At around 12:45 p.m., he left the café and asked his security detail to prepare his convoy to go back to the palace to attend a luncheon appointment. At around 12:49, he entered his armored vehicle, accompanied by Member of Parliament, Mr. Bassel Fuleyhan. At approximately 12:55, as the convoy passed a Mitsubishi Canter on Rue Minet El Hossein, outside the St. George's Hotel, the suicide bomber detonated the explosives. Mr. Hariri was driving himself. Seated next to him was Mr. Bassel Fuleyhan, MP. His car was the third in the convoy. Behind him were two more vehicles, and a makeshift ambulance followed the convoy. It had an internal security forces, or ISF, lead escort. The explosion occurred around 40 to 50 meters behind the lead vehicle in Mr. Hariri's convoy. Witnesses described two deep sounds, a second apart, a huge roaring sound, and a wave of hot pressure, a huge explosion, the sound of an aircraft going through the sound barrier, or a missile thrown by a large artillery gun. They also described it like an earthquake. The explosion was heard throughout the city, up to 25 kilometers away. While some could barely remember the ordeal due to the injuries and shock, and described it as, quote unquote, dreamlike, many gave a vivid account of the explosion and immediate aftermath. It severely damaged nearby buildings, such as the HSBC Bank. 70 to 80 firefighters arrived to try to put out the fire. Mr. Fuleyhan survived the immediate impact of the explosion. he was transferred from the American University of Beirut Medical Center to France for treatment, where he succumbed to his injuries only 2 months later. In February and March 2005, the Lebanese military intelligence and internal security forces conducted their own investigation and analysis of the explosion. Following a request from the Lebanese Prime Minister, the UN Secretary General dispatched a fact-finding mission to Beirut to inquire into the causes, the circumstances, and the consequences of this assassination. The investigation was not conducted according to international standards. It was mismanaged, disorganized, and there was a chaotic approach to the crime scene investigation, particularly in the initial period after the explosion. The crime scene was not properly secured. Critical evidence in the form of the vehicles in Mr. Hariri's convoy were removed by the ISF from the crime scene on the very evening of the attack. Tow trucks and other heavy-duty vehicles drove onto the crime scene in order to do this. The crime scene was damaged. It was also unnecessary. There was no urgency. The trial chamber finds incomprehensible what happened. There was no proper coordination of the initial investigation. There was, in the trial chamber's view, no coordinated procedure to search for missing persons in the days following the explosion. The body of one victim was found only after repeated attempts by his family to search for him at the crime scene on their own, and on one occasion with search dogs, which they brought on site and paid for themselves. They found his body some 17 days afterwards. Another victim's body was found the day after the explosion and was probably alive for 12 hours afterwards and may otherwise have survived had he received timely medical treatment. In the year after the explosion, international forensic teams from Switzerland, the Netherlands, the United Kingdom, and Spain assisted and the UNIIC. That's the United Nations International Independent Investigation Commission. That it assisted the Lebanese investigating authorities until February 2009. International into various aspects of the explosion and in very difficult circumstances. This included explosives, ballistics, and forensic crime scene investigation, including Lebanese volunteers and international underwater diving teams and experts in identifying vehicle parts, and forensic science and human identification. The various investigations collected key evidence at the crime scene, such as the vehicle parts and some of the human remains. The gross deficiencies in the initial investigation, in our view, did not affect in any material manner the evidence underlying the issues that required the trial chamber's deliberation on the guilt of the accused. However, strong lessons must be learned from what occurred. We now move on to the explosion. The attack was a detonation reaction of high explosives. The damage and destruction to the St. George's and Byblos hotels demonstrated the nature of the explosion. The St. George's Hotel, for example, suffered a bent column and canopy. A 3.5-meter section of the 20-centimeter thick front wall of the Byblos Hotel was pushed back 60 centimeters by the explosion. The mangled metal fragments found at the scene of the explosion and the presence of what is called, quote, washout, unquote, on several of them further confirms that high explosives were used during the attack. This was an enormous explosion. The quantity of explosives used was between 2,500 to 3,000 kilograms of TNT equivalent. The explosive used is RDX, which is also available as Semtex. Some witnesses observe that RDX is so powerful that it is most suitable for military purposes. It was detonated approximately 50 to 80 centimeters above ground level, and the explosive charge was rectangular in shape. It created a crater that, based on the cone shape, had a diameter of around 11 to 4 meters with a depth of around 1.9 meters within a margin of error of several %. The expert evidence was that an explosion in a narrow street with tall buildings with few openings will create higher peak pressure and peak impulse values because of reflections from nearby walls. This is known as the canyon effect, quote unquote. The explosives were loaded on the cargo tray of the back of a white Mitsubishi Canter, a common type of light truck covered in a tarpaulin. This vehicle, stolen in Japan, was imported into Lebanon from the United Arab Emirates in December of 2004, and then sold in Tripoli in mid-January 2005 to 2 unknown men. Parts of the canter were recovered at the crime scene and in the waters of the nearby port. The engine block identifies it as the Japanese canter. Mr. Hariri's convoy was equipped with jamming devices designed to prevent a remote detonation of a bomb. They were activated and working on the fatal day. The consensus of the various Lebanese and international investigation teams was that a suicide bomber triggered the explosion. The trial chamber agrees. Each team eliminated the other possible means of detonation as inappropriate for targeting a moving convoy of vehicles. This leaves only the possibility of a remote control device or a suicide bomber. The trial chamber has found beyond a reasonable doubt that 23 people died in the explosion or in the aftermath of the blast, including the suicide bomber. However, only 20 complete bodies were recovered from the crime scene. The remains of an unidentified man were found near to the blast. In total, the experts and investigators recovered and identified 92 human parts belonging to him. The quantity of remains was small, with a combined weight of less than 1 kilogram. This included smaller pieces of tissue and bones. A burnt tooth sample from this person did not match the DNA profile of Ahmad Abu Adas, the young Palestinian man in the false claim video. His DNA profile was not found at the crime scene. Based on the DNA evidence found at the scene and the analysis of DNA samples from Mr. Abu Adas's family members, the trial chamber is satisfied beyond a reasonable doubt that Mr. Abu Adas was not the suicide bomber. The unidentified male was the closest in proximity, within 1 to 2 meters of the explosive device when it detonated. He was most likely the suicide bomber in the trial chamber's opinion. Beyond the evidence that the tooth belonged to a young male in his early 20s, there is no further identifying evidence in the human remains analyzed by the forensic experts on his identity. The trial chamber, therefore, cannot make a finding on the unidentified male's identity. We now turn to the mobile telephone networks. The prosecutor alleges that the 4 accused and Mr. Badruddin carried out Mr. Hariri's assassination by using groups of mobiles that operated as networks. These were mobile groups with a high frequency of contacts within the group. The green network of 3 mobiles allegedly monitored and coordinated the attack and the false claim of responsibility. The red network of 8 mobiles carried out the assassination of Mr. Hariri. The blue network of 15 mobiles and the yellow network of 13 mobiles were used to prepare for the attack, including the surveillance of Mr. Hariri. The 3 mobiles in the 5th group, the purple mobiles, were used to communicate with each other and others outside the group to coordinate the false claim of responsibility. This may sound complicated, and indeed it is or was very complicated trying to unravel what occurred by examining cell site and call data records. The handsets and SIM cards were purchased anonymously or with fake identification and paid in cash, including top-ups. Some handsets were swapped between mobiles in different networks. The trial chamber finds that the green, red, blue, and yellow networks were interconnected and coordinated with each other and operated as covert networks at the relevant times. The assassination team used 6 red mobiles, including on the day of the attack. At least 2 also used blue mobiles. Given their high forensic profile, the discovery of the red mobiles by investigators was inevitable. They were used in the area of the crime scene at the time immediately preceding the crime. The red network mobiles ceased use just before the explosion. Their users took extra care to limit their traceability, which meant that the anonymity of the users of the red mobiles was the most protected. This created a need for the blue mobiles, which could be used more generally for surveillance and other activities. As to attribution of the mobiles to the 4 accused and Mustafa Badruddin. The case against the 4 accused and proving Mr. Badruddin's pleaded role in the conspiracy charged depends upon the prosecution successfully proving that they were using specified mobiles. This is termed attribution, quote unquote. Proving this attribution of specified personal mobiles is the first step towards co-location of the network mobiles and their attributed personal mobiles. This part of the prosecution's case is factually very, very complicated. Neither the accused nor Mr. Badruddin had mobile subscriptions in their own names, which could have made the attribution analysis easier. The investigation worked backwards, quote unquote, by first identifying the patterns of mobile use in suspected closed networks that appeared to be connected with the surveillance and or assassination of Mr. Hariri, and then attempting to find mobiles that were co-locating with these identified network mobiles. They then had to identify who was using the mobiles that appeared to be co-locating with the network mobiles. Finally, this had to be connected to any known and provable events linked to the crimes. The investigators closely examined the circumstances surrounding the mobile use to attempt to find their users. The UNIIC and the prosecution engaged in a complex and time-consuming inquiry, checking for everything that could be gleaned from the associations, in inverted commas, of a targeted mobile, attempting to determine who was using it, to connect it with a suspect, or to identify a potential new suspect. This inquiry included analyzing each mobile's pattern of use, such as where it was used, who it was in contact with, and how often and who its contacts contacted. I now turn over to Judge Brady.
Taking the four accused in turn, Salim Jamil Ayash. According to the indictment, he was using 4 network mobiles, termed Yellow 294, Blue 233, Red 741, and Green 300. Mr. Ayash owned an apartment in Hadapi, Beirut, and used a family residence in Harouf in southern Lebanon, near Nabatie. He worked for the Lebanese Civil Defense at the Al-Duwair station near Harouf until February 2002, and then until November 2004 was the head of the Markaba station before transferring back to Al-Duwair. The prosecution led evidence of his personal mobile and landline use and the contacts of each number and what was termed the geographical profile, namely the cells that the mobiles were connecting to. This means where they were when they made and received calls, the numbers calling and called, and texts sent and received were termed the contact profile. The same technique was laboriously used with each mobile in the case and with each accused. From this, the investigators compiled a profile on each mobile that the prosecution used to submit that only the named accused person could have been using the particular mobile in question. Mr. Ayash used the landlines at the 2 properties which were in his name and personal mobiles numbered 165, 170, 935, and 091. These mobiles had similar contact profiles and were used as contact numbers for official and business purposes such as passport applications, family service providers, and for insurance claim and towing after his car was involved in an accident. The SIM of one was used in his BMW. He also traveled to Mecca to perform the Hajj in January 2004. While he was there, he used his bank card to withdraw cash from ATMs. The importance of this to the case is to compare his mobile usage then with his mobile usage a year later when he allegedly made another pilgrimage there. In January 2005, Mr. Ayyash was again recorded as traveling to Saudi Arabia from Beirut between 15 and 28 January. If he was not in Lebanon then, he could not have been using the 3 network mobiles, red, blue, and green. It would have to have been someone else. The prosecution case against him would fail on that basis alone. To prove that Mr. Ayyash remained in Lebanon, the prosecution compared the call patterns of the mobiles that Mr. Ayyash was using in January 2004 with those he was using in January 2005, and additionally their collocation with the yellow network mobile in 2004, number 669. Its SIM was also used in Mr. Ayyash's personal mobile 170. The trial chamber has found, but only on the preponderance of the evidence, namely the common movement and the number of overlapping cell activations, that it is more likely that Mr. Ayyash was yellow 669's principal user. The Lebanese border records and the flight manifest of Middle East Airlines show Mr. Ayyash leaving Lebanon for Saudi Arabia with his wife and daughter on 15 January 2005. He had obtained a special Hajj passport for the travel and had taken time off work for pilgrimage. However, his leave was cancelled and he was reimbursed a travel allowance on the basis that he was working for the civil defense, involved in duties such as firefighting and rescue work. Additionally, the trial chamber received evidence that the passport control system at Beirut airport at the time was inadequate as it was overwhelmed by thousands of pilgrims. Pilgrims with Hajj passports were checked in as a group, and their passports were collected as a group and given to the border officials for stamping. Individual identities were not checked. The Saudi records show Mr. Ayyash and his wife's names as entering and leaving, but not their daughter, who the Lebanese recorded as leaving and entering Lebanon. The system was flawed and unreliable at both ends. Mr. Ayyash's attributed network mobiles, Blue 233 and Green 300, remained active during the 2005 Hajj, and Red 741 started its network activities. The mobiles continued to collocate and move in tandem in the periods analyzed, including the 2005 Hajj. In contrast with personal mobile 165's handset change during the 2004 Hajj, personal mobiles 170 and 091 continued to use the same handset before and after the 2005 Hajj. These personal and network mobiles had a single user during the 2005 Hajj, except for the duration of mobile 091's separation from the other mobiles on the afternoon of 28th of January 2005. The trial chamber had therefore found that Mr. Ayyash remained in Lebanon and did not travel to the Hajj. This finding is essential for deciding whether he was involved in the attack. The evidence established that he was using Yellow 294 until 7 January 2005, based upon its collocation with his personal mobile 935 and their common calling patterns. Blue 233 was used for preparations in the attack on Mr. Hariri, including surveillance. It was used by Mr. Ayyash from Monday 10 January until at least 14 February 2005. Its collocation with Mr. Ayyash's personal mobiles 170 and 091 was such that the tri-chamber finds that they had a single user. Mr. Ayyash, according to the prosecutor, was Green 300's user from 30 September 2004 to Monday 14 February 2005 as one of 3 mobiles that were used to monitor and coordinate the preparation for the attack on Mr. Hariri. This mobile contacted only one other, Green 023, that the prosecutor attributed to Mustafa Badruddin. Green 300 made its final call on 14 February 2005, an hour before the attack on Mr. Hariri, connecting at the end of that call to a temporary relay cell placed on the back of a truck across the road from the Phoenicia Hotel, facing in the hotel's direction and close to the scene of the attack. This small temporary cell had a predicted coverage area of around 150 meters. The cumulative occurrences of possible collocations between Mr. Ayyash's personal mobile 935, 091, and 170 and the network mobiles Yellow 294 and Blue 233 with Green 300 over this period of 4.5 months has convinced the tri-chamber that these mobiles had a common user in Salim Ayyash. Red 741, according to the prosecutor in the amended consolidated indictment, was one of 6 red mobiles used by the assassination team. The prosecution attempted to prove that Mr. Ayyash was using it through its collocation with Mr. Ayyash's personal mobiles 091 and 170 and the network mobiles Blue 233 and Green 300. The attribution of this mobile is the key to the case. Whoever was using it was closely involved in Mr. Hariri's murder. Red 741 dislocated from mobile 091 on Wednesday 2nd February 2005 when it was topped up in Tripoli. Logically, whoever was topping up a group or network of mobiles took the mobiles from their individual users to Tripoli. The tri-chamber is satisfied beyond reasonable doubt, based on the totality of the evidence, that Red 741 also had the same user as these other mobiles analyzed above. That user was Mr. Ayyash from Friday 14 January to Monday 14 February 2005. The tri-chamber is therefore satisfied beyond reasonable doubt that Mr. Ayyash was the user of Red 741 from Friday 14 January to Monday 14 February 2005. The evidence also established that Mr. Ayyash had affiliation with Hizbullah. Hassan Habib Merai. The next accused is Hassan Habib Merai, who was alleged to have used his personal mobile, Purple 231, to organize the false claim of responsibility for the attack. Allegedly, he communicated with Mr. Badreddin exclusively on a green mobile number 071. The case that Mr. Mer'i was using either purple 231 or green 071 is circumstantial. Purple 231 was not subscribed in his name and was last used on Tuesday, 15 February 2005, the day after the attack. The prosecution sought to establish that Mr. Mer'i was using purple 231 by proving that he and his family were using a personal mobile number 6091, and then comparing the geographical and contact profiles of the two mobiles. From this, it then sought to demonstrate that purple 231 and green 071 were collocating in a manner proving that the two mobiles had a single user, namely Mr. Mer'i. The evidence proves that Mr. Mer'i and his family were using mobile 6091. The strongest piece of evidence linking purple 231 with him was in November 2004 when someone calling from purple 231 called a furniture store and gave the name Hassan Mer'i for the delivery of mattress to his address and giving the contact number of mobile 6091. During the trial, another mobile, termed the Grey Mobile, was put into evidence by the Mer'i defense as one potentially collocating with green 071, meaning that it was not Mr. Mer'i who was using purple 231. However, the prosecution then investigated the Grey Mobile and found evidence that incontrovertibly proved that Mr. Mer'i was its user. He was identified by his passport photograph, the mobile number, and SMS content, but it was collocating with purple 231. The trial chamber has found beyond reasonable doubt, based on the Grey Mobile, that Mr. Mer'i was using purple 231 at the relevant time. Whether Mr. Mer'i was using green 071 rests solely upon its collocation with purple 231 and the Grey Mobile. There is some reasonable evidence that the three mobiles could be collocating, but ultimately there was insufficient evidence to make a finding to the high standard of beyond reasonable doubt that Mr. Mer'i was using green 071. There were an adequate number of calls and significantly a lack of movement from which it could positively conclude that green 071 was collocating with either purple 231 or the Grey Mobile in a manner in which the two personal mobiles plus green 071 had a single user. The trial chamber was not satisfied beyond reasonable doubt that Mr. Mer'i was using a green network mobile. Hussein Hassan Onaisi. Hussein Hassan Onaisi was previously known as Hussein Hassan Isa. The prosecutor alleged that he was using his personal mobile purple 095 in the forced claim of responsibility. It was not subscribed in his name. It was last used on Wednesday, 16 February 2005. Numerous documents, such as applications to open bank accounts and to purchase a vehicle, use this as a contact number for Mr. Onaisi, who was then known as Hussein Isa. The call data records demonstrate that a significant number of the top 30 contacts are with numbers attributed to Mr. Onaisi's family, in-laws, and acquaintances. Most notably, the highest-ranking contact with a number attributable to his mother, with which Purple 095 had 747 contacts. The totality of the evidence points to him as its principal user. The only conclusion reasonably available from the totality of the evidence was that Mr. Onaisi was the principal user of Purple 095 from at least 9 January 2003 until 16 February 2005. The Tri-Chamber is satisfied of this beyond reasonable doubt. Asad Hassan Sabra. Mr. Sabra married Mrs. Hala Saloum in November 2000, and they lived in Beirut. He is alleged to have used a personal mobile, Purple 018, between November 2001 and 16 February 2005.